Welcome to California Virtual Family Law Attorney with founder Linda Garrett.
Welcome to California Virtual Family Law Attorney with founder Linda Garrett. Linda has been practicing family law in California for over 20 years and is the founder of the Law Office of Linda C. Garrett, based in Solano County. Through traditional representation and family law legal coaching, she helps individuals across California understand both the legal and financial sides of divorce so that they can make informed, confident decisions.
Yeah.
I'm Leanne Lyon, and today we are breaking down community property in California. Linda will explain what it means, what counts, and where people often get confused. Hello, Linda.
Hi, good afternoon. Thanks for having me on the show.
It's great to see you again. So, Linda, to get started,
Yes.
can you explain what community property means under California law?
Yes. So, California, I sound like a little teacher here, but in California, we are like one of maybe 6 or 9 states in all of the United States that have what are known as community property laws. And more times than not, when I speak to someone, they don't really know what that means. They've heard the phrase, but essentially, community property in its simplified term is as follows. This is me saying this. That's not quoting from a book or statute, but the statutes pretty much says as follows. And listen to every word. It's anything and everything acquired during the marriage is community property. You'll say, oh, okay. If somebody will say, okay, but that doesn't mean my 401k or the car that I bought, right? Or the house that's in my name. Well, were those purchased during the marriage? I get the yeah. Well, yeah, but. Well, did I say anything about a name? I'm like, no. So that's the thing. So as we have this conversation, I do have to verbalize a disclaimer. I know it's in somewhere on the podcast and fine-tune writing, but for this conversation, I call it the 75-25 rule, that whatever I say on this podcast is true about 75% of the time, but the other 25%, it is not. There are exceptions, and even exceptions to exceptions. So if anyone's watching this, that's you, is take this with a grain of salt because your facts may not fit. But generally speaking, under the 75% rule, if it was acquired during marriage, it is community property. Now, we do have exceptions, but I won't go into those because that's another 3-hour conversation.
So then what is separate property?
Excellent question. So separate property is 3 types. It's the stuff you owned before you got married that you brought into the marriage, and it still exists as of date of separation. And I did a podcast on what that is, date of separation. But it's essentially, think of it like a corpse. The corpse is the marriage. It died. And so what existed on the date of death, which is date of separation. And so one of the things that is considered separate property is something you brought in, like your pearls from, no, not that one. You brought in your high school ring you bought, your college ring, some furniture that you brought in because you had in your old apartment, what have you. If it still exists, that's considered separate property. Again, this is a 75, 25% rule. But that's one example. Another one is things you received during the marriage. One of them is an inheritance. So Aunt Gertrude dies and she leaves you $1 million. So that is your separate property. But again, with every rule, there's an exception and sometimes exceptions to the exceptions. And one of them with inheritance, okay, what did you do with that $1 million? Did you put it in your separate property checking or savings? Oh, no, I put it into the joint account. Okay, now we're having some issues under the exception to the exception rule. But typically speaking, if there's an inheritance, simple. We put into a separate account in your name. You kept it there forever and ever. And it's still there as a date of separation. That's considered separate. And then those things that you or he acquired, whether that's debt or assets after the separation, was separate property income or separate property assets. And a good example that comes up is, oh, well, that's fine. I bought a brand new car just last week. We've been separated for a year. Great. Sounds good so far. But then what did you use for the money? Oh, what do you mean? Well, easy question. Where did the money come from? Our joint savings account. Does that matter, Miss Garrett? Yes, it does. Again, those are the exceptions to the exceptions. But if you typically bought a car, used your separate property, post separate property earnings, separate. So before, during, and after. And then those are known as confirmation. We don't divide separate. We confirm separate. We divide community. And either is confirmed by the two of you, or if there's a dispute, like an inheritance, you put in both your names, is resolved by the judge. And either say we're going to divide it, or it's going to be confirmed.
So you brought up something in there that I think comes up frequently. You hear of people separating, and then one spouse says, I'm going to go max out the cards. So, how are debts handled? Are credit cards and loans divided the same way as assets?
Yes, they are, because they're all community property. That's the thing. So I call it the good, the bad, the ugly. The good is the assets, the bad is the debt, and the ugly is liabilities like lawsuits. And so that's why we have to have, and this is a refresher of why data separation is so important, because that's what ends the us period. It's like if we bought a car, we bought a house, we put deposits to the 401k, and just that one 401ks are a very common issue because they're usually hybrid. You started the job before you got married, you're putting deposits in before, during, and after separation. So the question is, what is ours versus what is mine? And so the data separation is important. So when it comes to debts, like you mentioned, where the husband or the wife says, you were separated as of this date, I'm going to go ahead and charge all these cards. After separation, again, there's exceptions to the rule. I get back to that 75-25% rule, even with debts. But statistically, under the 75% rule, is it debts acquired or credit card debt, for this example, after data separation, that person's separate property debt. And that's what we have to have cutoff. When did the us start and when did the us end?
So, what happens if one spouse owned property before the marriage? It could be anything from, like you said, jewelry to maybe gold, but it increased in value during the marriage.
That's a loaded question, but let me break it down to its simplest of simplest. So using your example with the gold, if that gold has been sitting in that person's safe deposit box and it was worth, I'll just say $2, it was of no value, but now today it's worth, let's say, $2 million, that retains its separate property value because one, you can't change its character. You can't turn gold into anything but that. Maybe one example is you have gold and you decide to melt it down and give your wife all this jewelry from this gold. That's a 25% rule we talked about. But if the gold is as it was, it's the separate property. But here's what's interesting, and this happens quite often. This is actually one of my cases from many years ago where the husband he's in his 60s, he's a millionaire. He decides to marry a woman from the Philippines, like a mail order bride, if you will. And she's like 21, very beautiful. And he decides to bring her to the States. They get married. He bought himself a house in a city called Benicia, California for $400,000 in cash. So it's clearly his house, paid for in cash before he got married. And he then, during the marriage, decides to put her name on the house. So the question is, for our viewers and yourself, Leanne, is it our house or is it still my house? And what does your intuition tell you? Because it's probably right.
My intuition says it's their house. Am I right?
Mhm.
Okay.
It's called a transmutation, where you actually change its character, meaning separate property, into a new character, which is now community property. And so if the house is worth $1 million or $2 million, that's now half our house, half the value. So either you're going to buy me out or you have to give it to me and we do an exchange of some sort. But yeah, it's our house. So at the end of the day, though, we really do have to make sure the person understands the data separation. What is that cutoff? Because that's the we versus the me period. And we have to discern which is it. Is it mine or yours or ours?
So I'm going to pick up on that with a real estate background. Does that date of separation then determine the value? Because values in real estate don't change drastically, but they do change. And they can go up and they can go down. So is the date of separation value?
This For this example, we'll assume this is clearly community property was purchased during the marriage. They've been living in the house. The income earned during the marriage has been paying the mortgage, and so it's 1000% community property. So now wife says to husband, "I want to divorce you. Actually, I am divorcing you, and there's nothing you can do to save this marriage. Nothing. I'm going to the courthouse on Monday." So she files for divorce. So is the value set when she files? No. So then the question becomes, so when do we set the value? However, before we ask that question, we ask, what will we do with the house? That's a bigger question, because one of the questions is, can I buy her out or buy him out?
Mhm.
And then if not, then we have to sell it. So in a house situation, the parties have two options. Either one buys the other out at a fair market value, or what they have to sell the house and divide the proceeds. So in the context of the buyout, the value is going to be set, from my experience, when they reach their agreement. So let's just say she filed for divorce 2 years ago. They still have the divorce in the court. And now they're like exhausted from this divorce. Okay, fine, let's not fight. Let's just resolve some of these issues. What about the house? And so he says, well, she says, I'll buy you out. He says, okay, that's fine. You can buy me out. But the value is going to be set. And I tell people that they both either A, get independent certified appraisers so that they have two numbers to compare against and then meet in the middle where there's a difference, as it always is, or B, agree to one certified appraiser and that person sets the value. And let's say they say it's $1 million today and they settle the case today. So now wife has to, if she's going to buy him out, she's got to refinance the house. She's got to give him his net equity share of the house because there's a mortgage on the house. So if there's $1 million value, $500,000 of debt, she owes him 250. That's one way. So the value is set on the date of the agreement because now the work has to be done to pay him off. If they don't agree and they can't decide on who buys the other out, or they disagree, they just agree to sell the house, then it's going to be set at the time of, essentially, if there's a trial, the court will set the value at the date of trial, or the value is what it is when it's sold. That's how we know what the value is. It got sold. We sold it for 1.2 million. The debt was 500,000, and now we have the balance to equally divide after escrow fees. So it's not a black and white. That's the thing. And that's why I think people should talk to an attorney. At least get the coaching, is to kind of know their options, because that's where a very common area where people tell me what they want. And I'm like, it's not, she says, oh, he cheated on me. So I'm going to take the house and I'm going to do this. And I'm like, so you're unemployed, right? Yeah. And I said, and you're going to buy him out with what? Well, I'll do a trade with him. Okay, well, fine. You give him all the stocks and blah, blah, blah. So then how are you going to pay the mortgage? The mortgage? So, so I think when it comes to houses, for sure, people definitely, that's one of the mistakes people do make, is not speaking to an attorney before they make decisions. Because then I get the call a year or two later, Miss Garrett, how do I change get rid of this judgment because I don't agree anymore? I said, well, you should have talked to an attorney. Good luck.
Mhm. Yeah. I've even heard of courts appointing a real estate agent because the couple can't agree on an agent or can't agree. So it can get very complicated.
But we don't have that much in California where the courts agree. There are times when there are experts in some of these, like, let's say you're dealing with someone who's a millionaire and they've got businesses and buildings in downtown Los Angeles, and they'll
Mhm.
appoint an expert who does real estate. But in most cases, the
Mm.
95% of divorces that I've dealt with in California, it's the mom and pop, husband and wife, a few properties, and it's just them getting their own appraisers.
So let's talk quickly about 401ks, pensions, IRAs.
Yes.
How do those get characterized and divided?
Yes, lots of times I will talk to my clients about what's called a hybrid. They'll ask me, "So is the 401k mine? It's in my name. I did the work. It's my employer." And I say, "No." They're like, "Oh, yes or no?" It's a yeah. It's both. And because normally it's a hybrid. So what courts and the law reflects is we do what's called a time rule. A time rule is where we say, using a fraction where the denominator is the years you've worked for this employer, and the numerator is the number of years you were married and put contributions into the 401k or the whatever you want to call it, the retirement vehicle, whether it's a SEP IRA, 401k, 403b, doesn't matter, but we'll just call that X. So it's the number of years you were married, putting deposits in or accumulating credits divided by the number of years working for that employer. And so sometimes it's easy because the person was married for over 30 years, same job, all the deposits during the marriage. They decide to get divorced in their 70s. It happens. I have had those cases. They're not fun. And the 100% is to be equally divided through what's called a quadro, which stands for Qualified Domestic Relations Order. So the employer, when it's time to give the parties or pay out of the retirement, that percentage goes to the non-employee and the other percentage goes to the employee. But it's a time rule. So whether it's, you can call it X. X is anything that's retirement, 401k, 403bs, CalPERS, DFAS with military pensions, IRAs, SEP IRAs, anything related to retirement, we would use the time rule as a default with law. But I want to say this, with everything I will say in this podcast and any other podcast, it ultimately comes down to any issue will be resolved in one of two ways, which is either A, an agreement of the parties, which is say, yes, 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 do that, please, you'll be sane. Or B, the court has to decide in a hearing or a trial. Anything, even data separation, we don't agree. I actually had a case once where the husband, his name was Richard, and I digress, I do that. He was coming to me, wanting to get divorced. And I said, okay, Richard, how long were you married? And he says, no, I said, when did you separate? He goes, oh, scared. I separated from my wife 26 years ago. I said, okay. How was it 26 years ago? That was today. I got my suitcases. I went to my apartment complex that I owned before marriage, Miss Garrett, and I've been there ever since. I said, okay, sounds pretty good. Did you acquire other assets during the marriage? He goes, oh, got tons of buildings and apartment complexes. They're all mine. He's not proud of himself. So then I get a response to the divorce from the wife. And she says date of separation was 2 months ago. 26 years? 2 months. So I call up the attorney for the wife and I'm like, so why is it 2 months? I go, my client said blah, blah, blah. And she says, yeah, she agrees. He moved out. She agrees he's in the apartment. I said, so what's the problem? She goes, well, didn't he also tell you that they lived as husband and wife otherwise? I go, what do you mean? They would have sex twice a week. They were together for all of the holidays. He was there all the time. He just didn't sleep there. He did everything else. So like, oh, hold that thought. I'll call you back. I call up the attorney, my client. I said, Richard, I have a question for you. Did you by chance have sex with your wife on a regular basis? And his response, till the day I die, Leanne, he goes, quote, well, Miss Garrett, I did have to service my wife. Close quote. I said, Richard, you did not. And guess what? All those houses and buildings you bought these last 26 years, they are half hers. True story.
Wow.
Yeah. Yeah.
True story.
I digress.
Truth is
It happens.
stranger than fiction sometimes.
If
So
you only knew. Yes.
there we go.
And so that's the tricky thing. So we have what people think are black and white with retirement accounts, for example, but things happen. Um, yeah, I know they're not about retirement, but it goes back to the intent of the parties. And in the case of the retirement vehicles, we would use a time rule. So I'm kind of circling back.
Excellent.
Yes.
Well, as you can hear, audience, there is a lot involved, and this is probably why you want to talk to somebody who knows a thing or two. So that is it for today's episode of California Virtual Family Law Attorney with Linda Garrett. If you'd like to learn more about Linda's family law legal coaching or traditional representation services, visit lindagarrettlaw.com. Thank you for listening, and remember to like, subscribe to the show, and leave a review if you found this episode especially helpful.
Thank you.
Thank you, Linda.
Thank you. Bye-bye.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.